Welcome to today's webinar hosted by the Net Zero Transition Panel on behalf of Adam Knight, who is the chair of that panel. And I know he is logged in, but he's asked me to chair this one today. I'm Rachel Bridge. I'm chair of the Guild and also work for Fisher German, so involved with this panel. I'm delighted that we've got Rob Garden from CMS and Mark Gilkes from Fisher German, who are here to talk to us today about development consent orders and the reform that has been going on over the last few months. And I'm sure that everybody that's logged in will be interested to see what the outcome of that has been. Before I hand over, I'd just like to ask if anybody has any questions, if you can drop them into the chat function on the screen, then I will keep an eye on those questions. And as we go through the discussion between Rob and Mark, Rob's going to start, I will just pause them to ask questions when we get to relevant points rather than waiting for them all to the end. The idea is that this session is as interactive as possible, so please do raise questions, and if we want to expand on points, raise a hand and we can drop you into the meeting. And I will hand over to Rob now.
That's great. Thanks, Rach, and good afternoon, everybody. Thanks for attending. As Rach says, I'm going to talk about DCOs and in particular reform, but I think before I kind of get into the government's current programme of reform, it's worth setting the scene in terms of what a DCO is and why the regime was introduced. So DCO is a development consent order, and it's essentially a piece of legislation you're granted by the Secretary of State, and it's mandatory for certain projects to go through the DCO regime, particularly for pipelines. That's for projects, sort of gas pipeline projects that may be over 40 kilometres, meet certain thresholds, and if you hit those thresholds, you have to apply to the Secretary of State to get a development consent order. There are also other circumstances where you may not hit those thresholds, but you've got a project that you would want to consent that way, for example, because it brings in compulsory purchase powers or sweeps up other consents, and there's the ability to seek a Section 35 direction in order to do that. And in the kind of pipeline context, projects have done that previously. So the HyNet hydrogen pipeline is an example of a project that has got a Section 35% coming into the DCO regime. So the regime itself was introduced in 2008 through the Planning Act 2008, and it was introduced really off the back of other infrastructure projects, and primarily the Heathrow Terminal 5 project, which took in the region of kind of 5 years to go through public inquiry, and it was recognised that was obviously far too long to get major infrastructure consented. Since the regime's been introduced, there have been more than 100 DCOs that have come through, including a number of pipeline DCO projects, and the majority of those have been granted by the Secretary of State. So it's a regime that has kind of come into effect to consent nationally significant infrastructure, and generally I would say it's working well. In terms of the kind of timeline for consenting a DCO, I thought it was useful to share this slide to give a flavour for how long it takes to go through the process at present. And some of these steps are set by statute, so there are statutory timelines that apply. Others are more indicative. The pre-application phase, I'll touch later, and Mark will touch on as well, on sort of some of the key building blocks to consenting a DCO project. But there are a number of different requirements that apply in terms of things like consultation and environmental surveys, so that there is quite a long lead-in time to consenting a project through the DCO regime. And generally, we say that takes in the region of 2 years. And I think that's particularly correct in the pipeline industry, where you're likely to have a long linear project that will require engagement with multiple landowners, but also consultation over kind of quite a wide area, and a lot of survey work as well. And that time frame can be shorter for simpler projects, but you have to squeeze into that consultation and survey. So generally 2 years is a good rule of thumb, and it may well be longer for more complex linear projects. So that part of the process is primarily in your gift as a project promoter, and you design your program. It's not prescribed. When you actually get to making an application, you do then hit some of the prescribed timelines. The first of those is acceptance. So you submit an application And effectively, the planning inspectorate who deal with these things. You may hear me talk about PINs later, but that's the planning inspectorate who essentially manage the process on behalf of the Secretary of State. They have a 28-day validation exercise, which is effectively to determine whether you comply with the procedure, whether they can accept your application for examination. There's then a pre-examination phase, and during that phase, there's no set timeline, but it generally takes about 3 or 4 months. And in that phase, you'll have third parties able to register as relevant parties, interested parties. You'll also have what's known as the examining authority, which is essentially one or more planning inspectors who are appointed to examine the project appointed, and they will look at what the issues are that they want to hear. Following that, you're then into a 6-month examination phase. And again, that is currently set by statute. It's a maximum of 6 months, and the planning inspectorate is kind of very proud on sticking to that. They've only got 1 or 2 examples where they've gone beyond, and effectively a result of COVID, the impact that had on hearings. And that examination phase is effectively where the examiners who are appointed will scrutinise the project, ask questions. There'll be hearings. It's quite a time-intensive process, where everybody gets to have their say in the project. And if you've got compulsory purchase, again, you'll have compulsory purchase hearings during that 6 months. Following that, you have another 6-month period, which is broken up by 2 3-month periods. The first 3 months is where the examining authorities will make their recommendation to the Secretary of State on whether or not to make the DCO. And again, the planning inspectorate stick to that 3-month timeline. So they will submit their report within the time frame. And following that, there's a 3-month decision time frame for the Secretary of State to reach a decision. And this is one of the areas where the regime has slightly slipped in recent times. During the kind of first half of the last decade, when the first projects were coming through, the Secretary of State would stick to that 3-month timeline. More recently, a lot of projects have been delayed, ordinarily because there are issues to resolve, things like habitat regulation assessments that haven't been resolved through the examination. But in some cases, that decision timeline is kind of going out to even beyond a year. So that's one of the things that they're going to focus on and reform. I think it's worth saying in terms of pipeline projects that have come through so far, the majority of them have come through in accordance with that timeline. So they've stuck to the 6-month examination and the 6 months for recommendation and decision. So the key building blocks and things that are probably different to the DCO process are flagged 4 on this screen here. But there are 4 things that you really need to do at the pre-application stage and have in mind. That's firstly environmental and planning work. There's a lot of environmental work that needs to be done up front in terms of surveying and production of documents. So you'll have a scoping report you need to submit, but when you get into the consultation phase, you also need to produce what's called a preliminary environmental information report, or a PEIR, and that is effectively a full environmental statement in draft at the pre-application stage. So that's a statutory requirement. It means the environmental work, there's a lot of scrutiny on that up front. Similarly, for consultation, for most planning processes, you don't have prescribed pre-application consultation requirements. But under the DCO regime, there are strict procedural requirements around who you consult and how you consult. And that's really important, I think, for a pipeline project in particular, because that means a lot of land referencing work at an early stage to make sure you've identified everybody who you need to consult. Linked to that is also compulsory purchase. Again, for a pipeline project, it's highly likely that you will need to have an element of compulsory purchase in your DCO. So you need to be doing the work up front to identify landowners, to engage with landowners, to demonstrate some of the standard tests that apply for compulsory purchase. There are kind of no alternatives in the public interest test. And then examination, I mentioned earlier. For a lot of projects that don't go down the DCO regime, you may well rely on permitted development rights or potentially planning, and you never have to get into a kind of inquiry or adversarial or inquisitorial process. The examination for a DCO will take place regardless, and the inspectors are kind of trained to scrutinise and look for issues, potentially even if they're not raised by third parties. So that means the standard documents that you produce at the point of submission of your application need to be able to effectively kind of inquiry status documents that stand up to scrutiny. And so again, there's a real element of front loading work that goes through all of these key building blocks.
One thing I
just when you actually getting your application in.
One thing I'll just jump in on, Rob. When you put them on a screen like that, they look like building blocks that you could just go and, okay, we'll tick that off, and it's very easy to put that in a program. Okay, we'll do our surveys. But one of the key challenges of the DCO and the kind of probably most of the people on this call, it's that integration with where you're going and what you're doing and the land that's actually required, and that kind of engineering and construction input means the timelines and the kind of programming these activities is really challenging. Surveys, of course, we could do, you can get an environmental consultant, they can do all the surveys they like in the perfect survey season. But if the design changes halfway through and you've just finished newt surveys, you've got to wait till the following year till you can go and reassess them. And it's that kind of managing of all of these building blocks within a program that's quite challenging. Yes, I'd say engineering kind of sits across all of those and helping you understand which land you're actually impacting for all of those building blocks.
Yeah, absolutely, Mark. And it's particularly with the environmental and also consultation, because if your design changes and you potentially bring in more land, then you're going to have to go out and reconsult. So that engineering design really is critical for all of these. So that's some background to where the DCO regime is and some of the key elements of that regime. What's been going on for a number of years through the government, through various departments. It was previously called Project Speed, and it's now called the NSIP Reform Action Plan. But it's effectively how can we consent projects more quickly? And the drivers for this are things like the offshore wind targets, but also hydrogen targets in 2030, for example, which are creeping up very quickly and already becoming quite difficult to hit for projects going through the consenting process. So it's all aimed at kind of better, faster, greener, fairer, and then more resilient. There are 5 areas that the government identified in the recent action plan. I'll focus primarily today on really reform area 2, which is operational reform. But there are these 5 areas that they're looking at focusing on to expedite consenting through the DCO regime. Building on top of the action plan that came out in February was a consultation that the government issued in July 2023, and that was on 3 of those key areas: operational reform, community, and the system capability. And system capability is another big point, just with both PINs and planning inspectorate, but also consultees who are really stretched just with the sheer number of DCO projects that are coming forward at the moment. And so they were the focus on this July 2023 consultation, and there are a number of measures, 10 key measures that were set out in that. Three of which I think we can focus on today because they really relate to how promoters of projects can influence the regime. The first is strengthening the pre-application process. So that process we talked about is there consultation and ensuring that's effective and proportionate. The second is looking at operational reform, so faster, more proportionate examinations. And then the third is actually looking at, well, okay, how can we actually establish a fast track route to consent so you get your DCO quicker at the back end process.
Rob, is it, sorry, just to on the previous slide, you talked about consultees being stretched, and I think in the context of this forum, it's probably worth explaining that's not just landowners and kind of your usual people you interact with on a scheme. It also includes your local authorities and stuff, doesn't it?
Yeah, exactly. So there is a prescribed list of consultees that you need to engage with when you're promoting a project. Key consultees for any project, but particularly pipeline, will be your local planning authorities, but also bodies like the Environment Agency, Natural England, and they're all well versed in the regime, particularly under Natural England, the Environment Agency. But they are stretched, and there are increasingly kind of more projects coming forward in each district area. it's important to engage with them and try and support engagement by potentially putting agreements in place with them, etc. So you've got a way in with those consultees. Kind of following on from that and the strengthening this pre-application stage, one of the things that Fins wanted to introduce and the government wanted to introduce, and it's now come in through the Levelling Up and Regeneration Act 2023, so at the back end of last year, is effectively the ability for certain authorities to charge and recover fees. And the aim of this is so that all of those bodies have the funding in place and it's paid for effectively by project promoters, but they have the funding in place to actually provide you with the pre-application advice that you need. And from a promoter perspective, there's occasionally the instinct of, well, why do I want to consult these bodies, or seeing it as a burden? But what I would say kind of experience shows is engaging with all the consultees at the pre-application stage and where the real value is in terms of getting through the consenting process as quickly as possible. Because what we don't want is somebody like a Natural England raising an issue as you get closer to examination, or even in examination, but then becomes difficult to deal with. And that's certainly what has happened on projects previously that have been delayed at the decision-making phase, as issues haven't been addressed at pre-application, but perhaps could have been. You're then left with paying for that in programme times on the back end, which is eating into delivery time frame.
Rob, on that, would you, obviously planning performance agreements have been in place with the councils on a kind of voluntary basis, I guess, on previous projects. Is this almost taking that regime beyond just those planning authorities and offering it to your environment agencies, I guess, or who? I don't know if that list exists yet, which you've noted in your slides.
Yeah, so there'll be regs that will come in, but I mean, Natural England and the Environment Agency will ordinarily be able to get an agreement with them, which is similar to a planning performance agreement already, to effectively fund requirements. So I think it's just going to be extending that. I would always say it's worth doing.
But it's an approach that a lot of projects are already kind of seen as a bottleneck, haven't they, and have kind of gone about resolving it in project-specific planning performance agreements where they'll already be funding the council or the local authority to assist making their decisions and whatnot.
I was just going to ask as well, and just to clarify, Rob, so the cost of that presumably will go back to the acquiring authority, whoever it is that's seeking the DCO.
It will, yeah. So as with kind of planning performance agreements with local planning authorities, the cost will be borne by project promoters. So it is another cost to factor into the scheme in terms of meeting the costs of those statutory consultees.
Yeah, and presumably that will vary as well, local authority to local authority. It won't be a consistent scale.
Yeah, I think it will vary in practice, based on a number of factors, the nature of the project and who you're dealing with at local authority level. Some local authorities are really experienced on this and have had, and there are even authorities who've had a lot of government financing to help if they're hosting a lot of infrastructure. I think it will still vary.
I guess the rules of the real world still exist, though, that you can give the council some money, but that doesn't magic another person into their office to help that's experienced to make the decision. So
it's all kind of points to just early engagement, effectively, to understand where they are and you can help them to decide. I think it's the best way of looking at it. More effective and proportionate consultation is another element that has been talked about. I think more guidance will come out on that. I would approach that with a note of caution, because there are various documents you have to produce, and ultimately I think the extent of consultation will be a project by project basis, but you've got to engage with local authorities as to what they think is appropriate, and really have regard to their feedback, and that's prescribed in the statute already in the Planning Act 2008, and that won't change. I think what might change is more guidance around what is proportionate, so you're not overdoing it with events or leafleting, but in reality, again, I wouldn't shy away from consultation with the public, and projects are moving more towards almost having an iterative design in some cases with the public to kind of bring them along. So I think use consultation as a positive rather than a hurdle. And one of the one of the key changes that is due to come in is from PINs is effectively then tiering their pre-application advice. So at the moment, projects can go in and speak to PINs, obtain advice, but that's relatively formulaic. PINs are very helpful. They'll meet you very frequently. They'll talk you through the process and what they expect to see. But it's all relatively kind of standard, and they're still proposing this standard approach. But they're essentially bringing in tiers where they could have basic advice where you don't need quite as much, you don't need quite as much PINs in inputs. So that might be a project that has no compulsory purchase or nothing contentious to it, through to more advanced and enhanced advice from PINs, which will give you more access, and potentially apply where you've got novel complex projects and those that go into the fast track process. I think more important than that is actually the ability for PINs to give what they're calling merits-based advice. So when you speak to PINs at the moment, it's all very much kind of procedural driven, what you need to do to get an application in. And it looks like there's going to be a move away from that. So effectively, if you're providing them with documents or your proposed approach, getting more advice from PINs on the merits of that. So is that a good idea? How an inspector view it, as opposed to really doesn't tick a procedural box, which may do, but may not be a great idea. And the next point I think we'll start to see coming through anyway is faster and more proportionate examinations. And what I would say, having been involved in a number of examinations, you have that 6-month time limit, and there's a tendency for inspectors or interested parties perhaps to find issues to fill the time historically. But since project speed has come in, I think that has changed. And we're involved in a project for SSE, the SLAR multi-field project, which didn't involve compulsory purchase, and actually PINs were really pushing to complete the examination quicker. So in that case, we had an examination that closed within about 4.5 months rather than 6 months, because the issues had all been resolved. And I think ultimately, and I'll touch on some of the measures that PINs are actually consulting and looking to bring in. But I think this is all additional work that will be applied to promoters as they go through the pre-application phase, because what they really want to have is early identification of issues, so that examiners can ask the right question right from the outset, drill down into what the real issues are, and not the kind of unearthing issues or having third parties making issues later in the process. And I think that's another area where this will change. Is at the moment, third parties can and do raise issues throughout the whole process. And I think the examining authority and the inspectors will be far stricter in terms of, if you've got a representation to make, you make it in full at the outset, and the infernal new issues popping up later in examination. And then the element that's kind of got the most headlines, I guess, from the DCO regime is this faster consenting process, which is effectively giving the Secretary of State the ability to call for a shorter deadline than the 6 months. So at the moment, you've got the 6 months set out in the statute, and what the levelling up and regeneration period has introduced a new for the Secretary of State to direct for a shorter examination. That now came into force, and we're expecting some further information guidance. But what was in the July 2023 consultation is effectively a bit more about how this is actually expected to work, i.e. what projects it will relate to. And what PINs are looking to introduce is effectively a quality standard. And so whether a project can go through this faster consenting route will be a PINs decision. So if it's something you're interested in, and something you should be discussing with PINs right at the outset of your project at the pre-application stage, and because a lot of the work that will go into determining whether there is faster consenting route will be driven by the pre-application document. And the key test that PINs are introducing is this principal area of disagreement test, which is effectively the areas of disagreement that are clear and have been narrowed, so there aren't a huge amount of areas of disagreement. When we talk about areas of disagreement, what that relates to is potentially objections, whether it's from landowners on compulsory purchase matters, or statutory consultees. Again, it could be Natural England in relation to the impact of a project on a wildlife site. It could be the local authority, highways authority, in terms of the impact on highways. So that's going to be the key test for projects to get through this fast route. There are a couple of other tests that PIMS will look to again, which are procedural based. But effectively, they are that you've taken all the steps that can be set out in the pre-application phase, and there's guidance that's due to be expected due to be issued by PIMS setting out those steps. And secondly, also that you've had regard to advice. So when we talk about meeting a PIM and that enhanced pre-application advice that they may provide, they will expect you, if you want to go through the route, to demonstrate that you've had regard and you've had regard to their advice in designing your project. The further guidance to be published on that. But I think a good example of what this will look like is already out there, and there's what's called the early adopters program, which PIMS put up and called for interested projects to participate in last year. And this pilot program is currently running. It runs until spring 24. And there are a number of projects that signed up to this early adopters program. And effectively, what PIMS identified through this was a number of measures. So I'll put them on the slide here, but 10 key measures that they expect to be deployed for people to go through the fast track process. And they are effectively all additional steps that you as a developer will have to take. So I think the onus remains on developers at the pre-application phase here. But ultimately, what PIMS have set out with what a project should really be doing to get to DCO submission stage with issues as well. There are documents like issues trackers, like policy compliance documents that should be produced. I think the additional steps are things like program plans, which will be very clearly setting out your program to consent, so helping consultees, and also evidence plans, which means effectively evidencing all the methodology you've used and agreement to that methodology for the consultee. So that could be engineering methodologies, it could be environmental assessment methodologies. They're all effectively new steps and new documents that have been badged that should be undertaken.
I was going to kind of contribute that whilst you might call it an issues tracker, we used to maintain compulsory acquisition schedules, which were essentially tracking the same things just under different document headings. And what project has anyone worked on that doesn't have a program? These are all things that kind of a project should have and be able to do. Now, I mean, some of them are more novel, like your pads and things like that, where they're it's a slightly different way of thinking about it. But I think in general, no one should really be I don't think there's anything in there that would make you fall off your chair if you're managing a project of, we're going to have to do stuff completely differently to get onto that adopter program.
Yeah, exactly. I mean, PAD is a good example, actually, Mark, where the regime probably doesn't work brilliantly at the moment. So at the moment, you have statement of common ground, which may have been involved in where you've had assets affected, but they're intended to help your inspectors and demonstrating what the key issues are. But they often go to sort of 10-20 pages, and it'll be 10-20 pages of meeting notes without really getting to the crux of the issue. And what these PADS documents are designed to do is they'll be worked up with the consultee, effectively say these are what we really in dispute about. This is what we think needs to be done to resolve it, and effectively also saying what the prospects of resolving it. So the examiners know what the issues are and who to engage with through the examination. So in terms of program, looking forward, that pilot program at the moment is in place and runs until spring 24, and then spring 24, which, as I was reminded by a government official last week, is one of the most elastic terms in governmental language. So effectively will probably run until our summer. But by spring 24, the government are looking to respond to the July 23 consultation and publish some of the key changes to regulations and guidance. So hopefully we'll start to see some of these measures come forward and apply to every project that goes through the regime and for the fast track consent route to become available. And then in 2025, another aim of PIMS is to be digital, agile, which is all aimed at helping environmental perspective primarily, but sure that the program digitization of information, and also publish and update MPSs. And I think actually from an industry perspective, that's a really key issue. We had the energy MPSs designated yesterday. Until they were designated, the formal MPSs were from 2011, so no mention of things like hydrogen, things like solar power. So really important that those MPSs are updated more regularly, so can reflect on that industry is. So the overall summary to take away: evolution, not revolution, or to use Dave Brailsford's famous sporting phase, marginal gains, but all hopefully beneficial to the project. No, I just wanted to. Sorry,
carry on. I was just going to chip in that the digital and agile approach is quite interesting, isn't it? I mean, there's some bigger ticket wins in there, I think, potentially for those promoting their projects, and that PIN's supposedly going to be able to move to a digital mapping basis where there'll be a lot of base data for environmental surveys, and so if you're doing a project in the same footprint of a previous one, you don't need to necessarily go and re-survey everything, particularly trying to prove negatives, which always I found quite odd in certain environmental surveys and stuff. So I think that there's 2025 some of those reforms could be quite interesting to see how they develop and if they can stay on track. Because they're big asks, they really are, like digital mapping across, multiple projects with lots of different data sources and stuff. I can see it becoming quite challenging. But
it's a huge exercise. I think requiring kind of changing mindset from some of the consultancy world.
Yeah.
To deliver that. And then kind of wrapping up where that leaves us, obviously put the timeline at the front, think about my natural, well, what does that mean for a timeline from now? And really, I think the pre-application phase, there's not much ability to shave time off that with the reforms, but what we can be doing at that stage to help the additional engagement piece, when you get to submit the application, and you're in as good a shape as you can to either get through the fast track consent route or to just get through the examination with a timely decision. The timelines I've put here in red are the proposed time for the fast track consent. So ultimately, as you can see, it's probably only 3, maybe 4 months that you shave off the process, but anytime you can is very helpful. The only other point I wanted to mention is post consent. That's all focused on actually getting the DCO. Once you've got the DCO, you may need to go in and change it, and there are 2 ways you can do that: either a material change or a non-material change. And the material change effectively operates in the same way as the DCO application itself, so you still have to go through all of that consultation process and examination. So it will take in the region of about 18 months to get a material change through. Non-material change still takes time, and until recently there was no process set for that. And we've worked on a number of projects which could involve potentially changing 2 or 3 words. One example is a project where we removed an upper capacity limit, not really an issue at all. No, still took more than 6 months to get consented because there's no time associated with it. So one of the steps we're going to take now to introduce a timeline for that.
That seems eminently sensible to me. There's been lots of projects where it's almost they try and live with what they've got because it's not significant enough to do a material change, and a non-material, the timescale risks are too high, so it puts pressure on contractors and engineers and probably some of the audience here to kind of construct pipelines or assets in non-optimal conditions because changing what you've got is so time-consuming or risky.
Yeah, absolutely. So I think this will really help. So yeah, stop sharing. That's the end.
Yeah, do you want me to just? I've just had a couple of extra slides if that's time, right? Share.
Yeah, please do, Mark. And equally, if anybody has any questions, drop them in the message chat, and we'll raise those as we go along.
Can you see that? Perfect. So I thought I'd just add, a few points on what hasn't changed as much as anything, in that we keep talking about DCO reform, and just wanted to kind of just reiterate that the process is very, very similar, and this isn't a revolutionary change that's going to shave lots of time off those programs that we might have liked, largely because you're still going to need to do all the pre-app work, and there's a lot to do there. There's a lot to plan for. There's lots of surveys to do. The examination program, which is obviously one of the main changes, that was always kind of out of our control, and it was just a lump of time that we were able to put in the program. But it was never a particular. It was, it was known, so you could plan around it. And so, whilst a small reduction in there is great, it was the uncertainty before examination that's always been the challenge to manage. And all of those challenges still exist. All those building blocks that Rob talked about at the beginning of his presentation are still there. And the other areas which have been identified, the ability to actually change your timescales are quite limited as far as I can see of this first round of reforms. And even if you start thinking about things like, the quite exciting reforms, like say we get all the environmental data onto a single mapping system and Natural England and everyone buy into it, I can find it impossible to believe that there won't be some degree of ground truthing that will still be required to be done. And that will still have to be done in the relevant survey season. And as I kind of set out at the beginning, it's great having your building blocks, but it's when the design is changing in and around those in a pre-application phase, which it has to, for it to be a meaningful consultation, you have to be, taking into account views and changes and making sure that you've got the right scheme. You can't just fix it on day one and just say we're never going to change it, because it wouldn't really be taking it through a pre-app or a consultation. So that they're always going to need to be managed and consulted on. And if you make a big enough change and it's at the wrong time of year, you then have to wait for more survey season to be available to, be able to, judge your impact on those changes. So yeah, there's lots of good ideas, I guess, but without fundamentally changing the process of this is a process of making sure people are consulted about the impacts of the scheme. It's you can't really shorten it dramatically without removing some of that ability for people to be consulted. Would be some of my main takeaways. Why can't I click?
Mark, I was just going to ask, Rob mentioned it as well, the impact of a lot of the people listening will be working in the kind of hotspot DCO locations where we talked about the statutory consultees, but also the landowners being impacted upon by lots of different schemes. How, what can we do to best manage that process? Because as a landowner, they're going to be receiving lots and lots of different pieces of communication from different schemes. What impacts that going to have?
You could just use one land agent for all of your schemes. That can make that a consistent message. No, it's really difficult. And we've worked on schemes where one landowner's got 3 different related but different DCOs crossing his land in different ways. And it's just a challenge of making sure your projects are communicating with each other. You understand the sequence of events between your projects. And on one of Rob's slides earlier, I don't know if you saw, one of the bullet points was multi-party meetings and events. That is essentially how we've managed those situations on those schemes. We've got reps from all the different schemes, and we've had a sit down and made sure that those landowners who are in those pinch spots, which is invariably why they're affected by so many schemes. You're trying to route your infrastructure through places which are difficult, so you all end up following similar routing criteria and similar obstacles to your schemes. You end up in the same spot, and there's not much we can invariably do about that. Multi-party meetings and just being clear and upfront with you and your other projects about your timescales is key. Don't know if Rob, you'd add anything?
Yeah, I think the only other thing I'd add to that, particularly on the East Coast and Suffolk and Lincolnshire, for example, where there are a lot of projects, we are seeing landowners, community groups springing up saying, put this in a coordinated corridor, work together. And there are examples of projects that are doing that. In Lincolnshire, there's a number of solar projects that design one big cable corridor, effectively came together to try and minimise the impact on landowners. So I think more of those discussions on understanding who you're working with, not against them, is really important.
I'd just carry on saying that some of the programme considerations and just some kind of general thoughts are, when you're planning your projects, if you want, program, one of the main exciting bits when they start talking about reform as program, that's always the challenge, on these large schemes, and all of the building, the kind of the things you need to do to maintain a good program are still in place. If you need to understand what you need to deliver, you need to make sure you understand the consents you need, the legal frameworks you want. You need good land right strategies and good systems, good project management, good communication, and that kind of thread which I talked about earlier of engineering and construction input throughout. None of those things will probably ever really change, no matter how much you reform the process. So yeah, I thought that was that's kind of was my main takeaway, and also the risk of some of the reform. What on one of Rob's earlier slides he talked about, more proportionate consultation, didn't you? And that just is slightly worrying for me, and that I think consultation should be viewed in a really positive light, and the more information you can take about your project out to talk to those, my world landowners, but also other stakeholders, that's when you really flush out where some of the challenges on these projects are, other people's plan developments, or just things that are not on public record that, might be affecting a piece of land. They might have another developer talking to them and we'd have no idea about that. And I don't think we should be scared of engagement, and with good systems and good strategies, it's all more information that help us come up with the right project and will help us have an easier examination. And so my view is the more consultation feedback, the better. The earlier you can get it, the more you can get it into your design. And a general rule of thumb is the earlier in a process you want to make a change to your project, the easier you're going to find that. If it's before a statutory consultation, that's great, and you record it as part of your design log. If it's after a statutory consultation, you may need to do another statutory consultation. If it's after you've submitted your application, we're back into non-material and material change considerations, where everything is other people to make that decision, then not you as a project. So yeah, I'd just be wary of going, pins don't worry, they're not worried about wider consultation or engagement. I think we need to be careful with that message. But much like Rob's summary, I don't think this is going to dramatically change much. But it's interesting, and it seems to be trying to evolve the process as much as possible. That would be all from me, Rach.
Thanks both. It's interesting, just as you were saying that, Mark, I was thinking about the sort of pre-feed process that we're going through and routing options, and how important now, if we want the DCO actual process to be as slick as physically possible, what can we front end do to make these processes as smooth as possible? Like if you had your dream design, what would you both say you'd love projects to do at this stage would just make the path clearer, make the program better, and we'll keep to budget?
Want to go first, Rob? Or I mean, what I like is a fixed design, but that's never going to happen, is it? Because the design is part of the iteration of the project, and when you're getting all of this information in, it's a complicated picture because there's so many moving parts, and it's just having a really clear give and get from all of the people that are working those different kind of parts of the project, people really understanding. And this is becoming easier the more projects we're going through with different companies, the understanding that people have of each other's deliverables, and you can actually hold someone up for something that you don't even realize you're holding them up for. So I'd just say it's all about that kind of project management and communication between all of your kind of technical specialties is quite key.
Yeah, definitely builds on that consistency. I think you touched on, Mark, in terms of citing, routing, and criteria you use, but you won't have a finalised design accepted. But as long as you've progressed as far as you can, if you've got flexibility and optionality, there's kind of a clear understanding why, so that we can explain that clearly to people. Ultimately, that the decisions we're making are consistent across the various groups.
Yeah, no, absolutely. It'd be really interesting. I think one of the key takeaways for me will be to see what happens in the final outcome of this process. So just going to put you on the spot and invite you back maybe in late spring, early summer to just confirm the findings so that those people that are members of the Guild can understand what impact that finally will have. Although I suspect based on both of your experiences, you've got a pretty, what you've explained today is what it's going to look like, but it'd be nice to have that confirmed. I'm just going to ask if anybody else has any questions or wants to raise a hand, then they can. Otherwise, I'm just going to thank you both on behalf of the Guild for taking the time out to present this to us. It will go on to the YouTube channel, so for those that aren't able to listen live, it'll be available on the channel, and our excellent HQ team will put a link on LinkedIn and other things so people can access this. Just on all other Guild matters, we have lots of events coming up over the next few months, including with the Net Zero Transition Panel, but also across the broader Guild. So go to our events page on the website and have a look at what we've got available. We have the annual dinner in March, and I believe, as of the last count before I joined this call, I think we have 5 tables left. So very small number of tables left, but if you do want to book a place, then please do get in touch with our events team at HQ. Or if you're interested in any sponsorship opportunities. But thank you both. I really appreciate your time today. I'm going to take the opportunity to close it out, and I look forward to speaking to you again soon.
Thanks, Rach. Thanks all.
Yeah, thank you, Rach. Thanks, everybody.
Thank you.
Okay, bye.